Attorney Ward, can you tell us how issues of alimony and property division are decided in a divorce case?
Concerning alimony and property division, there are statutes which list very specific factors that the court uses to decide regarding alimony, for example, whether or not to award alimony, and if so, for how long and what amount. And the factors overlap. Regarding an award of alimony, the court considers the following factors: the length of the marriage, the age of the parties, their health, their, quote, station, close quote, which is an old-fashioned word that basically means the style of living to which they're accustomed, what work they do, the amount and sources of their respective incomes, their vocational skills, what work they can do. It can be an issue that a party may claim that another party is intentionally underemployed, has greater skills than they're using, and that can be an issue. The employability of the party, and that connects to, for example, if there are small children and it's best for one of the parties to stay at home caring for the children, at least for some period of time, they are not as employable as someone who's free to go out and work. The, quote, estate of the parties, which is basically what property they have or what property will be awarded to whom as part of the outcome of the divorce. And the final factor is the needs of the parties. The statute does not give any particular weight to any particular factor. Experience tells us that those factors, and there's one last factor, which I'll address in a minute, of the factors I've listed, the courts focus most on the length of the marriage and the income and needs of the parties. The cause for the breakdown of the marriage is also a factor regarding the award of alimony or property. Regarding a division of property, all the factors I just listed are part of the consideration, and also the following factors are considered: the debt of the parties and how it's assigned, the opportunity of each party to acquire property in the future, and the contribution of the respective parties to the acquisition, preservation, and appreciation of the particular asset to be divided between the parties. The court, in conclusion, the courts in family law cases in general, and particularly regarding alimony, property, and even all issues, have a great deal of discretion. And the higher court would very rarely overturn the decision of a trial judge regarding those issues. About the only instance in which the trial court would do that, have that done, the appeals court would reverse the trial court, would be if the appeals court felt that the trial court clearly misapplied the law. But the appeals court does not retry the facts. That's left to the discretion of the trial court.